Hi, everyone, and welcome. My name is Jamie O'Connor, and I'm with Family Voices of Minnesota. Thank you for joining us today for this webinar on special needs planning. This is part 2 of a 2-part series on special needs planning, and today we're covering guardianship and conservatorship. Before I introduce our speaker today, I'm going to just quickly talk about who we are as Family Voices in case you haven't heard of us. Family Voices of Minnesota and the Connected Parent-to-Parent Support Program. We support families of children and youth with special health care needs. We do that by providing information, assistance, resources. We offer peer-to-peer support. We offer emotional support, understanding, and acceptance. And then we offer encouragement and education, for example, like our webinar today. Family Voices of Minnesota is the state affiliate organization for Family Voices National, and the Connected program is the state alliance member for Parent to Parent USA. Today we're joined by Scott Stevens, who is an estate planning attorney in Bloomington, Minnesota, and who is also the father of a young man with a special health care need or disability. And Scott also did part 1 of this webinar series, which was on special needs planning. You can access that on our website, familyvoicesofminnesota.org. I will also send a link in an email following this webinar. Scott?
Yes. Good afternoon, everyone. So today's presentation is on guardianship and conservatorship. So the first slide is general overview. A guardianship or a conservatorship can only be established through a legal action or proceeding. In that proceeding, the court makes a finding of incapacity for the protected person or ward based on clear and convincing evidence that the protected person or ward has been found to be unable to make necessary decisions on his or her own behalf. Once the court makes that finding, it then orders the appointment of a conservator and or a guardian to act as a decision maker for the protected person or ward. Guardianship or conservatorship should only be sought if the individual's judgment or decision making is a major threat to the individual's welfare. So, in order to establish an individual has incapacity, the petitioner or the person asking the court to appoint a conservator and or guardian proves an individual's incapacity by providing evidence to the court that the proposed ward protected person is unable to make responsible personal decisions and is also unable to meet his or her needs. And so with regards to my son, he's very, I don't know if gullible is the right word, but he's easily manipulated so that he can't manage money because he would give it all away. And that tends to happen with a lot of people who have special needs, is that they need someone to manage their finances because they're too easily swayed by other people, or similarly, they're not able to meet their everyday basic needs such as getting dressed, taking care of themselves, making medical appointments. And so in that case, in the case of a guardianship, an incapacitated person is an individual who, for reasons other than being a minor, is impaired to the extent of lacking sufficient understanding or capacity to make or communicate responsible personal decisions, and who has demonstrated deficits in behavior which evidence an inability to meet personal needs for medical care, nutrition, clothing, shelter, or safety, even with appropriate technological advances. And that's provided for in the Minnesota statute section that is cited there. And you're going to see that with appropriate technological advances throughout this presentation, and I'll explain why in a little bit. In the case of a conservatorship, An incapacitated person is an individual who, for reasons other than being a minor, is impaired to the extent of lacking sufficient understanding or capacity to make or communicate responsible personal decisions, and who has demonstrated deficits in behavior which evidence an inability to meet personal needs for medical care, nutrition, clothing, shelter, or safety, even with appropriate technological assistance. And the incapacity is proven by 1, clear and convincing evidence the individual is unable to manage property and business affairs because of an impairment in the ability to receive and evaluate information or make decisions. And again, even with the use of appropriate technological assistance, or because the individual is missing, detained, or unable to return to the United States. Now, that one I've never seen need to be used, but it's there in case someone is missing outside the United States or is detained and unable to return to the United States. 2, it's by preponderance of evidence that the individual has property that will be wasted or dissipated, which means spent unless management is provided, or money is needed for the support, care, education, health, and welfare of the individual or of individuals who are entitled to that individual support, and that protection is necessary or desirable to obtain or provide money. And finally, the respondent's identified needs cannot be met by less restrictive means, including use of appropriate technological assistance. And that's going to be prevalent or critical throughout this whole proceeding, because the court wants to impose the least restrictive remedy upon the proposed ward or protected person. They want to give them the greatest amount of freedom and ability possible. So the differences between a guardianship and a conservator is a guardian is appointed to make the personal decisions for the ward. The guardian has decision-making authority for matters such as choice of where to live, medical decisions, training, and education, whereas a conservator is appointed to make the financial decisions for the protected person. The conservator typically has the power to contract, to pay bills, invest assets, and perform other financial functions for the protected person. For a guardianship, here's the terminology. The person who is appointed to act on behalf of the individual is called the guardian, whereas the person who has the guardianship appointed is called the ward. The court appoints the guardian to make decisions regarding the ward's basic personal needs. Such decisions may include the choice of where to live and whether to consent or to refuse medical treatment. The guardian becomes responsible for making decisions in many areas of the ward's personal life. However, the guardian cannot decide all medical treatments because some medical treatments must be reviewed and approved by a court. At a conservatorship hearing, the court makes a finding of incapacity in specific areas where there has been clear and convincing evidence to support the finding, and a preponderance of evidence that the person's property will be dissipated or wasted without a conservator. The person who is appointed is called the conservator, and the person under the conservatorship is called the protected person. The conservatorship is tailored to transfer financial decision-making power to the conservator only in the areas of life where protection and supervision by a conservator has been proven necessary. If someone's under conservatorship, it does not assume or presume that the proposed protected person is incapacitated in all areas of his or her life. There is no evidence of or finding of general incompetence. The individual can still marry, can still make a will, and can still vote unless specified by the court that the individual is incapable of voting, and that would be based upon the input of generally the parents and medical providers as to whether the proposed protected person has the capacity to research and make informed decisions with regards to whom to vote for. Now, whether a guardianship or conservator is necessary. Generally, people who may be thought to be in need of a guardian or conservator include many different types of people, such as a person with a developmental disability, a person who is mentally ill, a person who has experienced a stroke or a head injury which may have resulted in a mental or physical disability, a person who has a disease such as Alzheimer's or who may be having diminished decision-making capacity. But it's always important to keep in mind that although a person may fit into one of these categories, this does not mean that he or she is necessarily incapacitated and in need of a guardian or conservator. That needs to be done on a case-by-case basis. A person's need for decision-making support or for a decision-maker will vary and depend upon his or her ability to make reasonable decisions, the availability of formal and informal support from family or friends or other resources, and adequate planning to assure that his or her needs are met. Guardianship or conservatorship and the need for support in decision-making have to be assessed for each person individually. The criteria for establishing a guardianship and or a conservatorship is based upon the court making a finding that 1, the person is incapacitated, 2, that the person needs the supervision or protection of a guardian or conservator, 3, that there is no appropriate alternative which exists which is less restrictive of the person's civil rights and liberties, and 4, that the person chosen to act as guardian or conservator is in the best interest of the proposed ward or protected person, that there's not another family member or person who their appointment would be better for the proposed ward or protected person. In order to determine incapacity, it requires assessing the 3 factors: impairment, functional capacity, and decisional capacity. Impairment generally refers to a person's diagnosed disability or medical condition, which may affect the person's decision-making skills. There is no statutory or legal definition of impairment, but it generally relates to a person's functional incapacity. Functional capacity means a person's ability to take action to meet personal needs or demonstrated behavior which indicates he or she can take appropriate or necessary actions to have needs met. It must be determined whether and how well the individual can perform activities to meet their personal needs and how much assistance is needed with decision making. Decisional capacity means a person's ability to understand, make, and communicate responsible personal decisions to make sure his or her needs are met. This is similar to informed consent evaluations. Is the person aware of an unmet need or inability in managing personal needs? Is the person aware of alternatives available to meet these needs? Is the person able to express a choice? And does the person understand and appreciate the choice made and the risks and the benefits? And then assessments. In order to proceed with a guardianship and conservatorship, there must be assessments. And they should be multidisciplinary, personalized, and comprehensive. Every attempt must be made to ensure that the assessments are sensitive to the language, religion, gender, and cultural differences of the person being assessed, and they should involve as much as possible family and close friends of the adult. And I'll just interject in here that, for example, I've been informed that in the Somali community, it's a custom of theirs to not look at authority figures in the eyes, that it's a matter of respect that they don't do that. But as a result, because one of the mannerisms associated with autism is the same thing, refusal to look authority figures or people in the eyes. And so there has been a overdiagnosis of autism, according to several different people I've spoken with in the Somali community, because their customs and the cultural is to not look, and so there has to be thorough assessments and further follow-up to ensure that the person being diagnosed actually does have autism and it's not related to a cultural or family situation. The assessment should not focus solely on a person's cognitive abilities, such as IQ, but should focus on the decisions to be made and the person's ability to understand what is required. A diagnosis of mental retardation or mental illness may not indicate the need for guardianship or conservator, nor does dependency. Instead, look for how that person copes with living. It must also be recognized that at present, the procedures and standards for determining competency are uncertain and controversial. So the different types of assessments are, you have medical. A medical assessment must be completed by a physician or a medical specialist. This should include the person's diagnoses, a list of any medications which may affect decision-making skills and abilities, and the results of testing to determine if there are treatable causes of the person's impairment. Behavioral assessment should be completed by a psychologist, care provider, or behavior specialist. This should include an assessment of any behaviors and necessary interventions which may affect the person's decision-making skills and abilities. And then an assessment of activities of daily living such as getting dressed, cooking, personal hygiene care, household cleaning, budgeting money, paying bills, etc. should be completed by a care provider, social services provider, occupational therapist, or physical therapist. This should include an assessment of functional capacity to act on decisions to assure personal and financial needs are met. Social history. A social history should be completed by the person, his or her family, and a social worker provider. A social services provider. This should include a background of the person, what led to the incapacity, what does the proposed ward or protected person in the family, if appropriate, think of guardianship or conservatorship, and the person's past and present decision-making skills. An intelligence test may be completed by a psychologist or a psychiatrist. This should include an assessment of decisional capacity to understand decisions that need to be made to meet the individual's personal and financial needs. Co-guardian, it's not unusual for parents to seek to be appointed as co-guardians or conservators, but for practical purposes and ease in decision making, it is recommended that no more than 2 co-guardians or conservators be appointed, because when co-guardians or conservators are appointed, both signatures are required for written consent, and this requires agreement with all of the decisions. Guardians and conservators must pass criminal background check in order to be appointed. So a background study must be completed before a court issues a final order appointing a guardian or conservator. If the proposed guardian or conservator has not been a resident of Minnesota for at least 10 years, the proposed guardian or conservator must also submit fingerprint cards as part of the background study request. The background study consent form and fingerprint cards are available at the court administration for the county you are located in. If the proposed guardian or conservator is not an individual, then the background study must be done on all individuals employed by the proposed guardian or conservator, in essence, the professional guardian and conservator entity. All their employees are subject to and must pass the background criminal check. And background studies, however, are not required if the proposed guardian or conservator is a state agency or county, a parent or guardian of the proposed ward or protected person who has mental retardation or related condition, if that parent or guardian has raised the proposed ward or protected person in the family home until the time the petition is filed, unless counsel appointed for the proposed ward or protected person requests the study. A bank with trust powers, bank and trust company, or trust companies are also not required to have criminal background checks due to the requirements and regulations that they're subject to. In order to establish a conservatorship or a guardianship, the petitioner or petitioners, usually the parents, must take the following actions. They complete and file a petition for appointment of guardian and or conservator, obtain and file physician statements from the ward's protected persons, physicians, psychologists, psychiatrists, etc. They complete and file an acceptance of appointment. If there's two, they each must complete and file in an acceptance. And then they have to send out a notice of hearing and notice of rights to the proposed protected person ward. And then they must also serve the petition for appointment of the guardian and or conservator, and then notice of hearing and notice of rights upon the ward of protected person. So they have to do that personally. That means it can't be done via mail. Either they personally deliver it, or you can arrange for a process serving company, or you can also have usually it's the sheriff's office who will personally serve these types of documents onto individuals. And then once that's done, draft and file an affidavit of service of the petition, as well as the notice of hearing and notice of rights. And then once that's done, you draft and file an affidavit of service by mail of all the court pleadings, documents upon the ward and protected person, and interested parties. So interested parties you will include any adult siblings if this is being done by parents, and if it's not being done by parents, then it'll go out wider, and it would include other adult siblings who are siblings of the proposed protected person, or it's going to follow a hierarchy based upon who you're seeking to have the guardianship proposed. So if it's for a parent, then any spouse and all their kids, and if they're adult grandkids, would receive notice. And any of them could show up and object to who's filed the petition, and then at that point the court will try to hear everything and determine who is the best person who should be appointed. Then there will be a hearing that the proposed ward protected person will attend with their own attorney. The court will appoint an attorney to represent the interests of the proposed ward or protected person. In addition, the county will send out the social services individual to do an in-home evaluation, and then based upon what the in-home evaluation finds and what the attorney finds, the court, if there's no objection, if they agree that this is in the best interest of the proposed ward or protected person, and a lot of times where it's parents seeking it for the children advise the attorneys and the court that they understand what's happening and they're fine with the parents being appointed. At that point, the court will then issue what are called letters of guardianship of the person or conservatorship of the estate, as well as an order appointing the parent or parents as general conservators or guardians of the individual. Once that's happened, then the person or persons who've been appointed as the guardian and or conservator need to draft a notice of entry of order and a right to appeal, and then they have to serve that notice of entry of order and right to appeal, as well as a copy of the order upon the ward protected person and their court-appointed attorney. And then once that's done, you draft and file an affidavit of service by mail of the notice of entry of the order and right to appeal upon the ward protected person and their court-appointed attorney. Now, I'm going to bring up one more thing, and then I'm going to go back. So now, something that I think a lot of people may not be aware of is that you can file to proceed in what's called informal papyrus. and that is where the ward or protected person is unable to financially pay the fees, costs, and security for costs in the the guardian conservator proceedings. The petitioner can proceed in informal pauperis, which means without payment. It means that they don't have sufficient funds, and they can therefore avoid the prepayment of filing fee, court visitor fee, and certified copies and photocopy fees. And this almost always is applicable to minors who are going to soon be adults, because they generally do not have the assets sufficient, they're small. They have very few assets, and therefore they qualify for this, and therefore it enables this to proceed with a lot less expenditure of fees than would otherwise be in place. And the way to do that is you draft and file a motion for proceeding informal pauperis, and you also draft and file an affidavit in support of motion for proceeding informal pauperis, and then you draft and file an ex parte order to proceed informal pauperis, and the court will review this, and as long as you've truthfully and accurately completed this, it will grant it, and then you've eliminated the need to pay a number of these expenses. And now I just want to point out that just highlight that I just talked about a minor, and it's really important that if you are going to seek to have a guardianship or a conservatorship created for a child or for a minor, that you do it while they're still a minor or under the age of 18. Schools are supposed to begin advising parents during IEP meetings in 10th grade about the need to obtain a guardianship and conservatorship for their child before they turn 18. Unfortunately, usually the staff and teachers are so focused on the academic and the social, job skills, independent living skills of the child that they don't do that in the IEP during 10th grade, and a lot of times they don't do it in the IEP 11th grade. And although they're supposed to begin doing this in 10th grade, once they're required, they have to do it in the school year that the child's going to turn 18. And so you can't obtain this before the year they're going to turn 18. And a lot of times the court will want you to wait until the month or so before the child is going to turn 18. But when I say that, I mean that means the hearing needs to be scheduled, and so you normally want to begin the paperwork and begin the process. I'd say probably 4 to 6 months in advance. It's going to depend a lot on the county, but if you don't get around to it right away, you just need to make sure that when this paperwork is filed with the court, that you advise them that the child is turning 18 on this date, and the hearing needs to be before that. And barring unforeseen circumstances, they will manage to schedule the hearing before the child's 18th birthday, so that this can all take place. And if you wait, unfortunately, if you wait until they turn 18, it just means there's a lot more jumps. There's a lot more, hoops to go through. There's a lot more work that needs to be done, because now they have reached the age of majority or adulthood, so they have a lot more civil rights in essence, because they're now adult, and so those all have to be now met and addressed. And so it is very beneficial to make sure this is all taken care of before the child turns 18. And now I also want to point out that a lot of times, given the fact that the individual that we're seeking the conservatorship or guardianship for does not have a lot of assets, you usually would just proceed with a guardianship proceeding, so that you would just be making their personal decisions and not so much their financial, because they don't have much assets now, and they likely won't have much assets in the future if you properly structure the estate plan for you and or other family members, and properly manage their situation. And the reason we avoid trying to obtain conservatorship is that the legal requirements imposed upon a conservator are just so much more stringent. You have to post a bond every year, and you have to submit accountings every year for everything you've done for the protected person ward, and there's a number of other things. But the bond you're posting is coming out of the ward or protected person's assets, and so it just doesn't make sense financially or logistically to obtain a conservatorship for an individual whose assets are minimal. Now, where this would not necessarily be applicable to is if the minor had been involved in a horrific accident and suffered traumatic injuries or brain injuries and received a very large insurance settlement, which unfortunately does happen on a fairly frequent basis. And so in that case, now they do have large amount of assets that will need to be managed. So in those types of situations, you would need to obtain both the guardianship as well as the conservatorship, and then just comply with all the legal and court-imposed requirements that go along with that. But that's kind of my presentation. I guess I went through it a little faster than I anticipated. Are there any questions? Or
Scott, I have a question, and I'm hoping some of our participants will formulate some as well. But a lot of your presentation was around what seemed to me like complicated legal procedures and language. Is attaining guardianship or conservatorship, or even determining if that's appropriate, something that a family can initiate on their own? Are we required to have a lawyer, for example?
No, you can initiate it on your own. The critical thing is when you're getting ready to initiate it is to touch base with essentially all of the medical providers for the individual and verify that they're in agreement that this person meets the medical definition of incapacity, and that they're willing and will provide their sort of written report stating that the medical diagnosis is that they're incapacitated and unlikely to come out of that within the next 12 months. And so you just, as long as you get your ducks in a row, it's feasible to do that, And the other thing, that not this isn't true for all attorneys, but what I do, and I'm not trying to toot my own horn here, is for parents who come to me seeking this, I do as little or as much as the parent or parents want. The more work that they can do to keep costs down, the better for them. I just want to be a resource for parents or for people seeking to get a guardianship or conservatorship in place. And so, in essence, the parents could either begin the process, and I would highly recommend they do that with regards to the medical providers, and start collecting all the documents and the medical opinions or at least getting them ready to be produced. And then, coming in for just sort of, the first meeting is always complimentary and free, and getting either more information there that would be sufficient to proceed entirely on their own, or to essentially just have myself or another attorney who's willing to do that, to only do the highly technical or legal aspects and let the parents do the rest. And it could be even where it's not necessary that the parents are represented at the hearing by counsel. It might be beneficial, but it's not required. The attorney, I could draft the paperwork and submit it, but do it sort of on their behalf and not indicate or file with the court like a certificate of representation that I'm actually representing the parents. But a lot of times I think parents like to have an attorney at the hearing just to make it smoother. I mean, the courts tend to be very forgiving and educational with parties who are representing themselves, but there's just sometimes things that come up or that they might get frustrated or upset at in certain circumstances. Did that answer the question?
Yes.
I hope so.
Thank
Yeah.
you.
So, but yeah, definitely the parents can begin the process and complete it. With maybe minimal input from an attorney.
And it sounds like they really need to engage with the child's medical providers.
Yes. That's always going to be really critical, is because they have to. They're the ones that are going to be essentially submitting or providing the parents or whomever the petitioner or petitioners are with the documents the court is going to rely on. The court needs to see one or more medical opinions indicating that this person does have an incapacity and is in need of a guardian and or conservator, and also, do they need, what powers need to be? I didn't go into this because it gets a little complicated, but what's the least, in the medical provider's opinion, what is the least intrusive or restrictive of the individual's civil rights? So do we grant the conservator or the guardian all powers under the statute, or only some powers under the statute with regards to either conservatorship? And so that's it's going to be. I mean, the parents may be, for lack of a better term, maybe the general contractor, but the general is not the one that'll do like the heating system in a house, or I mean, the engine is going to have to be the medical opinion, because they're going to, what they indicate and write is what's going to control or essentially control the court's decision making with regards to how encompassing is this guardian or conservatorship going to be.
We have a couple of questions, but because you're in that avenue of thinking, I want to follow up with one more that was on my mind, and that's that, I could easily see my daughter needing some co-decision making and some really structured learning about how to make decisions like this into her adulthood. But I'm hearing you say that it's really important, if you're going to try for guardianship, to try to start establishing that during their 17th year of 6 months prior to 18.
I'm sorry. Yeah.
No, that's okay. I guess my question is, how can it be structured if there's a belief that the individual could eventually, learn, and can there be, you mentioned like co-conservator, but can there be co-guardians where the parents are making decisions with the child, and is that something that is, I guess, legally mandated?
Well, when I say co-guardians, it's usually like the two parents or two adults, but ideally, yes, in our situation with my wife and I, our goal is to try to wean ourselves off as much as possible and let him, our goal is hopefully at some point we can terminate the guardianship. We do not have a conservatorship, but terminate the guardianship, because he has managed to, and if we're not able to terminate it, to at least reduce it or minimize our authority and role in it, and so we're always, he's continuing to work on how to manage money and all these skills that we're hoping that he will be able to, I don't know if I'll say master, but become good enough at it that we don't have to. Right now we have all the powers granted to a guardian, and the only reason is just because he, for lack of a better term, is just he's so vulnerable. He would. I mean, if we weren't there to remind him, he would go out in dead of winter in shorts and a t-shirt. I mean, and he would get cold, but he wouldn't realize it until it potentially was too late. And cooking, it's really hard. He has a real hard time. One, I mean, he loves shopping for groceries, but if you let him do the shopping, you're going to end up with a very unhealthy diet. And then he's not very good at. He's good at making some things, but he's not able to prepare foods or create a balanced meal or meal plan for himself.
He sounds like a teenager.
Yeah. Well, he's a teenager, but much more.
I understand
than that.
what you're saying.
No.
Yeah.
So yeah.
So we have. Go ahead.
No. Go ahead. I'm sorry.
No, it's good. We have a question about what happens if the child doesn't agree when asked in court, but also clearly is not able to make the decisions.
If the child does not agree that they don't agree that they think there's a guardian or conservatorship needed, or they don't agree that the parent or the parents should be the ones appointed.
I interpreted this to mean that the child thinks they do not need a guardian or conservator.
Then that's where the parents or the petitioners will be talking with the medical providers, because it's going to be, if the medical providers are in agreement that a guardianship or conservatorship is necessary, and the child's sort of disagreement might be sort of further evidence of that they're not able to realize sort of their inability to make these decisions. So if the child does not agree, it's going to come down even more so to the medical provider's opinions and what they've written to submit to the court, as well as taking testimony from the court. Will probably take testimony from one or both parents, and if the child disagrees, they'll be allowed to say why they disagree, and the court will, I would expect, would say, well, the medical providers think this is in your best interest, and try to work with the child to find out why, what's the basis for their disagreement, and try to address it. Because as I said, the court wants to make this as least restrictive as possible for the ward or protected person, and they don't want the ward or protected person to feel like sort of the court's sentencing them to some punishment or some.
Sure.
And
so you believe they aim to be collaborative and hear the concerns and want to know what the child, I guess, is wanting in terms of freedoms?
Correct.
So we have another question that's asking, is there anything a parent can do if their child doesn't have a diagnosis but is easily persuaded to make poor decisions? She gives the example of signing on a house or a vehicle that is obviously too expensive for them to pay for. The child can hold a job but just lacks the ability to make well-educated financial decisions.
I would, again, I would recommend consulting with the medical provider, and in that circumstance, I'm trying to think, you would probably want to try to get a consultation or have them meet with, and I'm trying to think who the appropriate person would be, whether it be like a social services individual or someone to have them discuss and delve into this person's ability to make reasonable, well-informed choices and decisions with regards to their financial management and purchasing. And I guess the question was, as you said, there are a number of teenagers who aren't able to make reasonable, well-informed financial decisions. But you would hope that as they get older, that you're able to work with them and help them build by giving them a credit card, maybe with a small a small limit, and just help them manage that until they're able to do it independently. But if it sounds like this is a much more significant or issue, and so I'm just trying to think of to talk to the and the medical providers might even have some recommendations, or I'm trying to think here whether the social services or and the other thing is that if they're a lot of times they don't have any diagnosis, there are classes. Well, I guess I think there are classes in like high school that deal with. I know my son took it, and so I don't know if it's for only people who have a disability diagnosis. I would expect not. But classes they can do in high school to try to work on that, and and get input from the teacher if they're taking that as to do you think they're what's your opinion of their ability to make reasonable financial decisions, manage the money? Do you detect any issues, or for lack of a better term, disability when it comes to that, or incapacity when it comes to that? So yeah, I would be proactive in reaching out to teachers or people. And again, I'm sorry, I'm drawing a blank as to who would be the best professionals to have a consultation.
We have one person asking if a developmental pediatrician would be a good resource in order to get a diagnosis, for example. Could a diagnosis be obtained for this reason?
The pediatrician, yeah. I mean, one of the opinions we got for our son was from his pediatrician, and then another one was from his psychiatrist, who helps to manage his mood swings and control his the meds to address some of his issues with autism and some of his other medical issues. And so we had two. One was from the pediatrician, and then one was from the psychiatrist, who, as I said, has helped him progress through puberty. That's not a pretty thing when you've got a number of different issues like autism and other ones, and then you've got all the hormones raging through you. And so yeah, definitely a pediatrician, or and the other thing is when you talk to the pediatrician, they might make a recommendation to you said a developmental, I think you said pediatrician, so that's to me is a subspecialty of pediatrics. But if it's just a pediatrician or even developmental, they might also have a recommendation for someone else to see, whether it's a psychiatrist or if you mentioned the financial aspect, they very well might have someone, whether it's a physician or another professional that they're aware is good at doing this type of stuff, or addressing those types of concerns and issues.
So this decision can be a really complex one for families, and we want to protect all of our children, but as you've been talking about, often our children who have special health care needs or cognitive disabilities are much more vulnerable. And so I know that we, as parents, we all share the experience of, not infringing on our children's rights, even that right to some risk of becoming an adult and trying things. And I heard you talk about, in terms of who can help discuss this decision, I heard you talk about medical professionals repeatedly, social service providers, I believe you said.
Right.
I think this is, in my opinion, this is another area where accessing other parents who have been through the process and made the decision could be really valuable. Are there other people that you would bring into this discussion to help with that decision making in the process? Professionals, obviously, law professionals who understand the process and the impact.
Well, I mean, I think it's going to, if we're talking about minor children, because it'll raise different issues if we're talking about like a parent or someone who's of an older age, because then I think there are other professionals that you would probably want to get involved in. For minors, I mean, as you say, I think other parents who've gone through this, I would think that you could probably the people could call up entities such as perhaps Fraser or Pacer. I'm trying, and just at least obtain information and or recommendations as to other people that you could talk with. The problem with Fraser is they're an excellent organization, but usually the wait list is really long to get in to have either a child start to be seen or to have quote unquote family therapy where they meet with the parent or parents and the child and discuss and try to work their way through these difficult issues. And then, as I said, there's Pacer, and I have not recently checked out the Pacer sort of, for lack of a better term, library as to all the resources they have, but that's an entity that comes to mind. And I bet you that another thing would be, depending on what the child's diagnosis or issues are. I mean, you could reach out to some of like the Autism Society of Minnesota. There's also, there are different entities, as you're well aware, that sort of try to raise awareness and provide guidance and assistance to individuals and families dealing with this, whether it's autism or whatever the medical issue or disability is. And I think they're always I found them to always be a really good resource for, if they're not able to help you directly, they're usually really they're really able to direct you to one or more people or entities that can assist you with the concern or issue that you have.
And I think, this is going to sound prescribed, but Family Voices of Minnesota, we have over 180 trained volunteer support parents throughout the state of Minnesota, and we have this ability to find the volunteer support parents who do have experience in this area, and I think they are always excellent resources for other resources. So not to sound like an advertisement, but I think that the value of what we're doing here today, Scott, is you're a parent presenting on this and sharing information and resources, and that there's more of that out there to share. So.
And I would have mentioned that too. I thought you were asking for ones other than Family Voices or medical providers.
Oh, yes, and I still have to, yes.
So
yes,
that I apologize for not mentioning them.
No.
I thought we were going beyond those.
No, that's my job. Yeah.
Okay, well that's good.
Are there any other questions? I think this put us right on time, but I see that Scott's contact information is up, and we will be sharing the archive of this webinar as well as the slides. I will send them out as an email to everyone who participated. Scott, it looks like we have one more question coming up. Hold on. What steps can a parent or friend take if they suspect a realtor or salesperson of taking advantage of a vulnerable adult financially?
So, and when we say a vulnerable adult financially, I guess that's a broad term, but if the person is under an incapacity and therefore does not have the legal capacity to enter into a contract, which would be required to buy a house or to buy a car or pretty much to buy anything, then if they don't have the capacity, that friend or family member can essentially undo the purchase by the vulnerable individual. It's and now I might get the term wrong. I think it's a voidable sale or transaction. I believe that's right. It's not void, but it can be voided if the vulnerable individual and/or family members or caretakers or whatever want to void it. So it's a one-way street. They can void it, but they're not required to. And then if that is the case, I would always, and I'm not sure what the proper entity would be, but I would report it to the realtor organization. There's a governing board or whatever that realtors are responsible to. If it's a financial individual at whether it's a bank or a financial planner, I would report them to that. And depending on how egregious it is, you can always report it to the county, either the police and turn it into a criminal matter, because at least in the Hennepin County and Ramsey County, I know they're on a real I don't know if crusade's the right word, but they've been really trying to crack down on exploitation of vulnerable individuals, of vulnerable adults, and so when in doubt, both investigate, see whether it is a voidable situation, and report it to any and all applicable governing bodies who sort of have the oversight and discipline authority over that profession, as well as the county attorney and/or police. And then if it's more than one, if it's like this seems to be a pattern, you can always also report it to the Minnesota Attorney General's office, because they're looking, they accept or ask for people to report that to them, because then they'll see there's a pattern that this realtor agency or this financial institution is doing it, and then they would pursue that entity. So that's off the top of my head. Those are the actions I would take in that situation.
Thank you, Scott.
You're welcome.
So I don't see any other questions, but again, you can follow up if you have additional questions. And Scott, thank you so much for your time and for your expertise. These webinars are really valuable.
Good. You're very welcome. And thanks for having me.
Yeah, our pleasure. To let everyone know, there is a survey as soon as you exit the webinar, and if you can dedicate 2 minutes to filling that out, it helps us produce material that is relevant for families and really valuable, and that's an important part of our mission. So thank you, everyone.
Thank you, Jamie.